Fulton. In answer to your question, there's no one that influences the jury except the jurors themselves. They speak with one another to determine whether, in their opinion, there may be a crime that has been committed and that the defendant has committed it. There's no defense attorney present. There may be witnesses present, but their own interpretation is what determines who's going to be receiving a true bill and a no bill. Thank you.
The next question goes to Attorney Michael Nelson, and this is, how is it determined what cases will go before a grand jury?
In order for you to go before a grand jury, you have to be charged with a felony. You have to commit a felony. That's the baseline. Now, felonies are cases that carry penalties beyond 6 months. They're cases that we get a year in jail. They stay at 5 levels of felonies, starting with the least serious, which are F5s, to the most serious, which are UFs, undetermined felonies, murder, killing babies, that kind of thing. So F1s and UFs, in cases that have death penalty specifications and that kind of thing. One interesting thing, this is just an aside, the charges, as you saw with the second grand jury, can also include misdemeanors, which can be added to a felony indictment. And those cases are determined by the complaint that's written by the police officer that arrests or investigate an arrest in a jurisdiction. They take that to the prosecutor's office. The prosecutor then determines whether those are felonies or misdemeanors. And if they're felonies, then they go to they're presented to a grand. If they suggest they are felonies, they go to a grand jury, whether it is determined whether in fact the allegations against an individual will in fact be felonies. Okay?
We have another question for you, sir. When a case is dismissed at the municipal level for lack of speedy trial, can you still be indicted, and what evidence is needed?
Now, remember, misdemeanor cases, if the question is just about misdemeanor cases, if it's dismissed for failure to have a speedy trial, it's dismissed. Now, so I'm going to make sure I'm clear on the question. That's not a grand jury problem. Now, there are instances where a case can be dismissed in the misdemeanor court and still be bound over to the grand jury for felony consideration. Oftentimes, you will go to court on a misdemeanor, and a couple of things may occur. The case may be dismissed at the misdemeanor level, and the police officers can then take it to their prosecutor, to the county prosecutor, who can then present it to a grand jury. But if the case is dismissed because it didn't meet its speedy trial requirements, that's the end of that case. But if you're asking if it's dismissed for lack of speedy trial in the misdemeanor case, can they then re-indict you as a felony, not on the same charges? But they can dismiss the case at the misdemeanor level and take it to the prosecutor's office, take it to the grand jury, and that happens like all the time. Okay? All right.
So again, I want to thank everybody for their insightful questions. This one is particularly interesting given the new technology of today. Are images on cell phones admissible in court or grand jury proceeding? As you remember, one of the prosecutors, Subodh Chandra, did present something on the phone and have people look at it, and I think it's an interesting question, and we are going to have Mr. John Martin respond to that one.
The answer is yes. You can use cell phone images as evidence in court. With any type of evidence like that, what you need is someone who can come in and say, this is the picture that I took, or I've looked at this picture and this is a fair and accurate representation of what happened. And of course, as Subodh mentioned before, when it comes to the grand jury, you don't have to have the actual person who can say that. You can have the police officer who says, I talked to that person and they told me that this is a picture of what took place, and that's good enough in the grand jury.
Another question, does the prosecutor have an obligation to honesty and to honestly presenting the facts? What keeps him or her honest? And we'll ask Attorney Michael Gold to answer this.
The prosecutor does have an obligation to be truthful and to be diligent. He does not have an obligation to present everything in a certain way. There were, to be truth, there are ways of lying, then there are the ways of lying. He can, I'm sorry. I do apologize for saying that. But the reality is, it is a self-checking system. Thank you.